Mario Joyner, your Las Vegas probate specialist, and welcome back for another video. Today I will answer a few questions I received regarding the following. Who has the right to a decedent's property if the decedent died intestate? Who has the right to a decedent's property if the decedent died testate? Where do I rank in relation to other family members? What happens to estranged family members? Now, there are two terms you just heard, and you will hear them later in this video, that I wanted to provide definitions for now before I go any further today. The two terms are intestate and testate. Now, I know I may have mentioned these terms before on other videos, and for some this will be a repeat, and for others it will be your first time. Intestate generally means that the decedent died without a will or trust, and therefore the laws of intestate succession in Nevada will apply. Secondly, testate means that the decedent died with a valid will and the decedent's estate will pass to the devisees or named parties in the will. Now, while this video includes information on certain probate procedures, before you initiate any probate matters, you should review these laws and consider consulting with an attorney. So let's begin, shall we? Who has the right to a decedent's property? That is, all the devisees, which are the people named in the will to receive assets, and heirs, which are family members who have an interest in the estate of the decedent, have an interest in the decedent's estate. Who has the right to a decedent's property if the decedent died intestate? If there was no will and the decedent died intestate, or if the will is considered invalid for any reason, then the estate will pass through the laws of intestate succession in Nevada. The decedent's separate property, however, is treated differently from the decedent's community property. The basic difference between the two is that separate property is property acquired before marriage, while community property is acquired during marriage. Exceptions like gifts and inheritance, even if they're acquired during marriage, are usually considered separate property unless commingled with community property. If the decedent died intestate and is survived by a spouse, children, grandchildren, parents, or siblings, then we use the intestate succession chart, which represents sections 134 of the Nevada revised statutes, to see how the property will pass. If the decedent is survived by a spouse and one child, the spouse will get all the community property, the spouse will get one half of the separate property, and the child will get one half of the separate property. Spouse and more than one child, the spouse will get all the community property again, the spouse will get 1/3 of the separate property, and the children will share 2/3 of the separate property. Children, but no spouse, parents, or siblings, the children will share in equal shares. This includes adopted children, children born outside of marriage, and children conceived during the decedent's life, but not born until after the decedent's death. Spouse, but no children, parents, or siblings, or grandchildren, the spouse will take the entire probate estate. Spouse and parents, but no children, the spouse will take all the community property. The spouse will take one half of the separate property, the father will take 1/4 of the separate property, mother will take 1/4 of the separate property. If there is only one parent, that surviving parent will take the other parent's share. Spouse and siblings, but no parents and children, the spouse will take all the community property, the spouse will take one half of the separate property, siblings will take one half of the separate property in equal shares. Parents, but no spouse or children, father takes one half of the estate, mother takes one half of the estate. If there's only one parent, that surviving parent will take the other parent's share. Siblings, nieces, nephews, but no spouse, children, or parents, brothers and sisters share the estate in equal parts. If a sibling is deceased, that sibling's children will share in the share that their parent would have received had that parent been alive. Now, there are certain exceptions to intestate succession. A surviving spouse and minor children's share of the estate might be increased pursuant to NRS 146. If an intestate heir properly exercises his power to disclaim, he or she will not receive anything. An heir can do this in writing if he or she is over 18 years of age, identifies the decedent and the property being disclaimed, signs off on it, and files it within a reasonable time after he or she acquires knowledge of the interest. If a decedent dies in possession of assets that do not rightfully belong to him or her, then they are not estate assets that can be distributed. Half siblings are treated equally as whole blood siblings unless the inheritance comes from the decedent by descent or devisee from an ancestor, in case those who are not of blood of the ancestor are excluded from inheritance. Now, who has the right to a decedent's property if the decedent died testate? If the judge validates the will and determines that the will governs, then the decedent's estate will pass to the devisees or named parties in the will. If the court finds the will to be invalid in whole or in part, then the intestate laws will govern. Hey, what do I rank in terms of in relation to other family members? In certain probate applications, the ranking of the application is important. If there is a survivor with higher or equal ranking to the applicant will need consents from those survivors and affidavit describing the status of those survivors, or to make sure those survivors are noticed of the application. Here's a general list of family ranking in order, the first being the highest ranking: the decedent's spouse, the decedent's adult son or daughter, the decedent's parents, the decedent's adult brother or sister, the decedent's grandchildren. Now, some probate applications require you to explain the whereabouts of all the family members who have equal or higher priority than you. For example, when petitioning for the cremation of your deceased brother, you would have to list all the family members who have equal or higher priority than you. Using the chart, that would mean all your brother's siblings, your brother's parents, your brother's children, and your brother's spouse. Each of those people will have to be listed in the petition. If they consent to the cremation, they can fill out a consent form. If they do not consent, or you do not know where they are, you will fill out an affidavit explaining why you do not know their whereabouts. 4. What happens to estranged family members? Now, most probate applications will ask for a list of all devisees and heirs. All family members, even if estranged, need to be listed on probate applications. If you know of a relative, even if he or she has not spoken to the family in years, you will still need to list him or her as a relative. Every probate application you submit to the court should be completed honestly, and you cannot cut a family member out of your application because you do not think he or she is entitled to anything. Now, there's a tip here. A common mistake that probate petitioners make is failing to list family members. You do not have the authority to determine who should be listed. You must list all the decedent's family members of equal or higher priority, even if someone has not been an active member of your family for years, or even if someone has been estranged from the decedent for years, or even if you knew the decedent mentally and emotionally disowned a family member, list that person. Disclosing of this information is necessary. If you take it upon yourself to try to keep this from the judge, you will be lying to the court. Now, in summary, I trust this information has been information that's been helpful in answering some questions regarding who has the right to a decedent's property if the decedent died intestate, who has the right to a decedent's property if the decedent died testate, what do I rank in relation to other family members, and what happens to estranged family members. If you would like a copy of the intestate succession chart, please reply in the comments section of this video or contact us directly, and we will distribute an electronic copy to you immediately. We continue our efforts to provide you with all the relevant probate information from our knowledge and experience assisting families going through the probate process. The information we share often reflects the questions or circumstances we encounter. Should you have a specific question or would like to discuss your situation, please contact us directly.